Good morning, Your Honor.
Good morning.
How are you doing today?
I'm doing well, and it's a pleasure to be able to participate in the interview with you. I'm a big fan of the Wicked series, from the Who Cares to the Hot Topics to Finding Your Niche. It's a great conversation that you're such a central part of for so many in the criminal bar in particular, but lots of others who tune in to see what's top of mind. So really grateful for all your efforts in leading this initiative.
Well, thank you very much. The honor is mine, Your Honor. I'm very grateful that you're here. You're taking the time out of your busy schedule. We know how busy Court of Appeal lawyers are, especially writing criminal cases. So it's really my pleasure that you're here. You're taking some time to talk to me today about something that I hope will be very beneficial to a lot of our practicing criminal lawyers. And today, what I would like to talk to you about, or what I would like you to tell us about more about, is some tips, some do's and don'ts that you think are important for practicing criminal defense lawyers or lawyers in general who are practicing in the Court of Appeal. And we'll start maybe by the written advocacy, because there's a lot of writing in appellate practice. Some lawyers don't feel very comfortable with that. So if you can maybe tell us and give us some tips, observations on your end on some of the things that lawyers should be doing more of or avoiding. And we can maybe start by lawyers who are practicing for the first time at the appellate level, and then move on to more senior lawyers, some of the tips that you would give for them as well.
Sure, and it's a good context to keep in mind that for our Court of Appeal, at least, criminal appeals are more than 50% of our docket, just slightly more. So all the judges of our court are sitting routinely on criminal appeals, and I say that because it means you can usually hit the ground running in terms of engaging with the key arguments, the issues that as counsel you really see as the strongest ones on the appeal, or anticipating the weakest ones and dealing with it. So, this isn't a situation where you need to start from scratch and go deep into the record to start. You can count on a bench that's reviewed all that written, not only advocacy, but the record from the trial or proceeding below. And what the judges are looking for is really something that is the compelling takeaway points. In other words, there'll be often discussion of going deep in the record, but one of the most frequently heard concerns of the bench in any appeal generally, but especially the criminal appeals, is where you get the sense this is simply relitigating questions that have been resolved below, particularly on findings of fact or exercises of discretion, areas where there's a high deference owed. So what you want from counsel in the written materials is that narrative of what the error is and why it's a compelling enough error to change the result, whether verdict or sentence or important pretrial voir dire, whatever it might be. And often, again, in criminal settings, it can be a focus on the jury charge in a jury trial, the focus on some of those decisions made along the way with mid-trial concern. So whatever it is, assume that the bench is looking to you for help in understanding that issue and what is compelling about resolving it in your client's favor. So again, avoid the trap of either approaching it like you would approach a trial or an application instead of focusing on what the error was. And again, the other trap of just trying so many different arguments, putting so many different issues before the bench, that the really strong ones, the ones that can warrant a positive result in the appeal, get lost in the shuffle.
Now, you did mention the jury cases as well. So those are a little bit more difficult because we don't really have reasons from juries. So what are some of the issues, or maybe if you can talk a little bit more about those types of appeals? And I think they're more challenging for a lot of
No,
criminal
I think
lawyers.
they definitely are more challenging, especially because the evolution of the case law has been towards, again, a greater deference to the judges on their charge and taking a functional and holistic approach, and not that kind of isolated search for a sentence here or a sentence there that may not be clear or may not get the point quite right, but looking at it as a whole. But I'd say that a couple of tips to keep in mind, especially in the criminal setting, where typically, although not always, appellate counsel are different than trial counsel. So you're dealing with picking up on a record below that you didn't necessarily shape as defense counsel or as Crown counsel. So one of the things, for example, that will come up for defense, the appellant most often, although not always, that defense counsel becomes appellant's counsel before the court, is where there weren't objections below to a section of the charge, for example, that now forms the basis of the appeal. And as appellant's counsel, you have to expect the question's going to come. I see this wasn't objected to below. What's your submission on that? And again, you should never be caught flat-footed on that. So even if you weren't there, so obviously you can't speak to what the mindset was or the back and forth was of trial counsel or the other lawyer, having some account ready. For example, this charge wasn't shared with counsel in advance, or was shared only the day of, or there was a colloquy on a related topic that explains why this wouldn't have been objected to, or there was no objection taken because the counsel understood the case as about X, but then the charge made it look like it was about Y, and that's what we're here to, whatever it might be, having that a full responsive account is really important, because when you hear counsel say, well, sorry, I wasn't there, or we can't know what lay in the minds of counsel objecting or not, or and certainly this is true, but it's not the strongest argument that the failure to object doesn't determine that it can't be a basis for a successful appeal if it was in fact an error in the charge. That's all true, but it's not what the judges are looking for. The judges are looking for help me understand why you're seeing it as a successful basis for appeal now as an error that's reversible, but trial counsel didn't see it as meriting an objection. So that's what I mean by joining in the conversation. The judges are looking for the help of counsel in understanding the problem and what potential errors might be that need addressing or correcting. And you want counsel to join in that, both on both sides, to see it in that shared sense of a conversation about problem solving, not just a performative exercise in advocacy, or not just an opportunity to say what's the strongest way to put my client's position forward. Sometimes acknowledging a weak link, acknowledging a challenge should have probably been objected to if I were the counsel, but I can't speak to the tactics that were top of mind below, is challenging. You don't want to throw trial counsel under a bus, but something that allows the court to understand a position in, again, a way that's contextually resonant is going to be always important.
Now, also in the written materials that we provide before the actual oral arguments, how much should be included in the materials that is an anticipation of the questions that we will get from the bench, or should we leave that to oral argument?
You're pointing out what the missing link was in my response there. All of that was in a way to say, anticipate that and put it in the written materials. Okay. Because once written materials are filed, read, digested, there's already a view of that case that judges will bring to the hearing. Now, of course, they're keeping an open mind that is there to be persuaded by the oral advocacy, and that discussion back and forth in the courtroom is invaluable in the process. But the written materials shape the understanding that the judges bring to it, the point of departure then for the question. So if you have, again, in a typical appeal where the defense becomes the appellant, and there wasn't that objection, and the Crown points it out in the respondent's factum, and you have nothing from the appellant's factum, then it's going to shape an understanding that this is a question that needs an answer. On the other hand, if you anticipate it, address it, and shape a different narrative of what was going on in the framing of that charge, then again, you're much more effective as appellant's counsel going in. So written materials, I think, are essential. And the other thing I'd say in response to that question is being focused, because I mentioned at the outset, when you just throw everything you can into that fact, you're both giving less time and space for the best arguments, and occasionally you'll have counsel come in on the day of the hearing and say, well, the factum deals with 4 grounds of appeal. I'm going to focus on 2 in the time I have, and I'll rely on the factum for the other 2. And again, that's a way of showing the priority setting that comes when you're really focused on what are the most successful, potentially successful arguments. And better yet, to do that winnowing in the course of writing the factum. So you're giving more space and depth and engagement to those potentially successful issues. Doesn't mean you don't cover off everything that was in the notice of appeal, but it may be that you are, again, conveying by that prioritizing where you want the judge's attention to go as well, and not to be diluted by a range of other issues that just aren't going to carry the day in the hearing.
So, but I mean, in terms of that point that you mentioned, because some lawyers prefer to just include all potential arguments that they can make, whether they're strong or not, and they just argue everything. And then there are some lawyers who prefer to just focus on 1 or 2 strong points and just ignore the others. So it is always better to focus everything and not to just put all potential arguments that can be made, I guess, in this case.
I mean, I think it's very hard to let go of any argument, and very hard also, some of this is shaped by having a notice of appeal that sets out the waterfront. And again, you can't have the appeal raise 4 grounds and the factum only deal with 2 without explaining what happened to the other 2.
Yeah.
And that notion of prioritizing and having more space allocated to the arguments that are anticipated to be the more engaging ones, the ones likelier to be successful, doesn't mean that you won't get a court or a judge pick up on one of the others and want more and want to explore it in greater depth. So the factum, does, I think, need to provide that coverage, but it doesn't mean every issue gets the same space or the same attention. And I think that's where you're also telegraphing to the court where they should be devoting more of their time and effort. And of course, some of this then becomes responsive in how the respondent's factum allocates its time and engagement and space, so that hopefully by the time it gets to that hearing, it's a really focused exchange on the most important contentious issues that are the likeliest to affect the outcome.
Now, it seems like the factum is definitely very important, because it's also the first impression that the judge is getting from counsel on what the arguments are going to be. But it seems like sometimes it feels like judges' minds are already made up at the factum level. So the issue here becomes, how important are oral arguments? Like, do they count? Is there any points in, like, can they persuade a judge who's read the factum and who kind of knows where they're going? Like, is there any hope at the oral argument level to change judge's mind?
Sorry, I want to make sure you finish the question, but yeah, I think there, it depends, of course, on individual judges, and I can't speak for all, but I can certainly speak for myself and the colleagues I sit with. And every bench of 3 is a slightly different alchemy. So this will also affect the engagement and the openness. But I've certainly come in with a view of a case based on the written materials that the oral hearing shifted in significant ways. And some of that is because the effective advocates will take the questions being asked as a very important opportunity to see what's top of mind in the bench's approach, and sometimes disabuse the bench if they have formed an impression that counsel thinks is either not right on the law or on the knock-on effects in the criminal justice system, the policy issues, or the equities of the case, and what is compelling about this individual context that needs to also shape how the broader principles are approached. So there's lots of opportunities to affect that narrative, to affect that understanding of the underlying law and the specific circumstances of the case that a good advocate will, again, not just present and then wait for the applause, but engage with the bench, see what's concerning the bench about their position, respond in ways that are authentic to the moment. In other words, not canned talking points, but really show that they're engaging with what the problem is. And again, sometimes that smart counsel will say, and if I haven't persuaded you on this point, here's the alternative argument, or here's the next point that will cumulatively show the strength of our argument. In other words, read the room as well, so that you're not just flogging an issue that clearly isn't going to be persuasive to the bench. So I'd say that strength on the counsel who are in conversation with you in the hearing, taking all the written materials as the point of departure, so not rehearsing them, not simply going over a summary of, I'm now going to take you to paragraphs 13 to 20 of the factum and summarize them. Assume that bench has read, digested, thought about that factum, and take the opportunity of those short minutes, and they're often, feel like they fly by in a hearing, but to really use them to add value from an advocacy point of view to responding to the concerns of the bench. And the bench, in my experience, very rarely just sits back and listens. They've got thoughts, they've formed either questions, concerns, some confusion arising from the written material that they put to counsel, usually pretty early in the back and forth, and that's where the opportunities really lie to change minds, or to shift the narrative, or to persuade the bench that there is a different way to see this case than they might have taken just from the written materials.
And so I understand the point that you just made, that the oral advocacy shouldn't be taken as a moment to just reread or restate what's in the factum. But then how else can you make it different? Like, should it be just a summary of the written argument? Or how can counsel in their oral arguments make sure that they're not just repeating and boring the bench with what they already provided in their written materials? Because the argument is going to be the same. They're not going to come up with a new argument in oral advocacy. So what tips here can you give to counsel so that when they're arguing, that it's different, that they're not just restating the same thing?
Yeah, no, it's a very good point. And I've seen a couple of strategies that I think are particularly effective in that regard. One is the counsel who begin with, you've got our factum, on the first ground of appeal, it's let's say it's a misapprehension of the evidence ground of appeal.
Yeah.
I've got the specific references in the record to where we say the evidence on this point was given, and simply can't lead to the conclusion or the inference or the statement in the trial judge's reasons flowing from it. And I'm happy to take the court through those references if that would be helpful. Also happy to address the test for misapprehension and the standard of review, and then you take some direction from the bench of where their issues lie. Sometimes what you're going to hear is, we're content just to have you take us through what you want to take us through. And again, in that environment, I think starting with the takeaway point, starting with we see the error in the charge or in the decision below on this ground of appeal to be this, and to be upfront, direct about it. Then to go back to here's the basis for it. And again, to check in with the bench in terms of level of detail, level of engagement with the record that's desired. So you're letting the bench have those opportunities both to digest what the takeaway point is up front, as opposed to I'm on the first ground of appeal going to start in volume 7 of the transcripts, line 20 of page 546, of the PDF, and suddenly you're starting off deep into the record without a clear sense of what the conclusion is that this all is going to be building up towards or in service of. So that's a strategy again to put, often you'll hear from Justice Laskin's important work on legal writing, the point first approach, save the wind up, give the pitch. There's an oral advocacy equivalent of that, where you start with that conclusion and then you allow the bench, to signal, is this going to be uphill or downhill to make that kind of argument? Be prepared to go to different aspects of the factum or the record in support of it. But it's a different approach than simply rehearsing those paragraphs of the factum. And I'd say, again, 9 times out of 10, it takes on a life of its own based on the questioning. You've got to, of course, be prepared if the bench is just going to say, this is your time, take us to what you want us to see, and to have those strongest points in the record, for example, that are cited in the factum to support a position, to go there. And again, sometimes getting into the transcripts, getting into the colloquies brings it to life for a bench. So it's not simply an abstract argument on legal principles. So sometimes that will be the best strategy. Other times it's a horribly complex transcript with too many different logic trees going on, and you got to pull back and give an accessible narrative to a bench that otherwise is just going to be overwhelmed by all of the record below. So those are the kinds of choices that counsel make that are important, and again shape how effective that engagement and conversation will be at the end of the day.
All right. And Your Honor, there's also, as we know, in an appellate context, we're not dealing with one judge, we're dealing with a panel. And there are some lawyers who routinely practice, who are appellate lawyers. That's all they do all the time. So they know the judges and they know their styles, and they know if they're dealing with a panel that is going to be more asking questions as opposed to a panel that's letting the lawyer do mostly the work. But I'm just wondering here, for new lawyers who are there for the first time and they don't know, they're not familiar with the panel, like what advice would you give them? Like how should they approach the panel when it's their first time, they're new, and they don't really know if they should take control?
No, it's a great question, and of course gives me a chance to plug our Ontario Court of Appeal direction to really aimed at senior counsel to make available opportunities for their juniors, for junior counsel to take on more roles in the advocacy where appropriate. We look to that. We expect it. We know those counsel in the second chair often have done most of the work on preparing the record, on developing a lot of the arguments, and nothing is going to get the attention of the bench more than to hear this is someone's first opportunity to make submissions to the Court of Appeal. And that should be, I know it doesn't sound like anyone wants to make a fuss sometimes, but I think it's a good practice to introduce someone if they're making submissions for the first time, for senior counsel to do that. If it's a sole counsel and it's their first opportunity in the Court of Appeal, to say, I'm here for my client, appellant, respondent, and this is my first opportunity to make submissions in the court, and I'm pleased to do so, and we'll start with the first ground. And just by doing that and signaling to the court, this is an opportunity to welcome that counsel to our community and to show that there is an understanding of there being a learning curve, so that things that might just be protocols and practices of the court that lawyers would get by osmosis who appear routinely. We wouldn't expect that from someone in their first appearances, and so it changes the dynamic. Of course, counsel will rise or fall on the quality of the arguments and the advocacy, but I think it's a really important practice to understand that we look to counsel to gain experience. We don't expect them to come with that already in hand. So it's for the bench to make sure that counsel understand what the expectations are. If, for example, they start in on reviewing the factum and the bench has read and understood what's in the written materials, it's again incumbent, I think, on the bench to say, look, we want to use this time by exploring this issue or this question that is on our minds. So counsel usually should be able to get those signals, but especially if they're not experienced with the court, to come ready for that, to not feel like if you're asked a question that you're going to get to in 2 issues down, to respond, well, I'm going to get there in a little bit. If you hold your horses, that's never something that's going to be a winning approach.
Yeah.
But to hear, well, I do have more submissions on that under the 3rd issue, but I'm very, very happy to give you a response now and to come back to it if it's helpful to do so later. Here's the response. So you're both signaling that I didn't forget about that. I'm getting to it. And since you've raised it now, it's top of mind for you. I want to deal with it now. And then when you get to that 3rd issue where you were going to raise it, to come back and say, here's where I deal in more detail with that question is if we've already dealt with it, I'm going to move on. But again, it shows both there's a rigor and a plan that counsel have brought in and a willingness to shift things around to engage in that conversation with the bench. So again, for new counsel, that can be the most unnerving part, but I'm in talking with some junior lawyers after their first appearances, I'm struck by how many are grateful for the interruptions, that their nerves are more kind of focused on getting through what they've written out and try to commit to memory and are thinking through. And the minute you get off that more sort of performative track to a conversation with someone who's interested in the case that no one knows more about than you, and you can have that authentic interaction, I find the nerves often just are no longer top of mind concern, and you're just engaged in the arguments back and forth, and that can be a welcome interruption for counsel in their first times out. But again, knowing what to expect, we all have every hearing now has a Zoom link, so checking out a few hearings in advance of especially the criminal weeks in our courtroom 10 give you a really early and helpful preview of what to expect, I think. And of course, all the mentorship that organizations like Wicked provide and others to ensure that even if you're on your own and it's your first opportunity, you never feel that the journey isn't a shared one, and there aren't opportunities to get sounding boards on the sorts of things to expect, or afterwards to debrief on what to learn from them and what went right, what went wrong. I think those are just essential to building this community of practice and to having it be the most valuable advocacy for the court is when you've got counsel on their able to put their best arguments forward. That's what we all want. So I think that sense of mentorship and engagement is key.
And I wanted to ask you, Your Honor, how important is style when it comes to appellate work? I understand that ultimately it's the most important thing is the quality of the argument, but is style important at all, whether it's in the written, in the factum, or in oral advocacy? Is there any importance for that?
Yeah, you know what, Maya, it's a great question, and I think there is a generational divide both among counsel and the style they bring, and in a way among the judges and the style that's effective for them. And remember, among judges on this court, we've got probably a good 20, 25 years range between them. So they're bringing different kind of cultural and community experience to bear. So, for example, there's some more aggressive kinds of
Yeah.
advocacy that some look for and want to engage with and see as exactly what appellate advocacy should be about. Others are going to be put off by that and are looking in the way I characterized it more for the conversation. For some, that conversation, and again, in a spirit and a time of bringing your authentic self and your whole self to what you do, can lead people to treat the appellate courtroom like a chat around some espresso at a place that they're relaxing, and that can be too for some too conversational.
Yeah.
So I say, first off, it has to be something in which the counsel feel they can be truly themselves in their advocacy. But I think understanding the role and understanding the responsiveness to the signals and the questions and the tone coming from the bench can be really important. And that's where sometimes you get a mismatch. For example, you get a colleague here who's used to a more kind of gruff and to the point style of questioning, and counsel who just aren't used to people, kind of interrupting them with that kind of tone, and it can be very off-putting. And you get the alternative sometimes, some counsel being very torqued up about an issue, and the court really wanting just to engage in a deeper conversation about it, and being put off by what seems to be a very performative approach. So there's no magic formula to it, except the general skill set of being able to read a room, being able to both not take things personally. So if there's a gruff question, it's not a reflection of often a lack of respect to counsel. It's in fact respecting that time is limited, and I want you to get to the point that's important to me. And similarly, when you get that opportunity to engage in a way that is never losing sight of the role you're in, and the importance of being that voice to a client whose liberty is on the line, whose opportunities at a second chance or important questions of their future are always hanging in the balance, and counsel that convey the arguments with that in mind, that why this matters so much, even if the back and forth is going to be one that may have some informality to it. Those are really important subtleties to good advocacy. But I'd say on style, the easy answer is it completely matters. The hard answer is to understand the ways in which that alignment or lack of alignment can have an impact on a successful oral hearing. But I think the same things that make us effective in our lives, in our relationships, in our collegial encounters, in how we deal with the other side, all reflect that. So, for example, one of the most welcome things to a bench is when you hear counsel have agreed on a whole range of things, or agreed on how they're going to approach the allocation of time and issues, or where there's counsel who clearly have talked about the question in advance and have made an arrangement to try to make that oral hearing more effective, or showing respect for each other. That goes a huge way in terms of confidence from the bench in those counsel. the counsel who are fighting on every single question and clearly are edgy and throwing shade on each other in lots of different ways, that typically does the reverse, undermines your confidence and trust in counsel. So those are things where it's not just style to the bench, it's style to each other. And again, counsel who are dismissive of each other, who aren't respectful of each other's client, those also telegraph important things to the bench that get picked up on. So style matters, but it doesn't just matter in a linear or one-dimensional way.
Mm-hmm. Right. And is there, other than the respect, like obviously when counsel are respectful, this is something that is appreciated by the bench, but other than that, is there something that is also problematic that judges usually see and that they don't like lawyers doing other than respect when it comes to style? Like, what is it, whether it's in the way, the tone, is there a specific tone that irritates the bench more than other tones?
Well, I'd say that two things, one substantive and one kind of more stylistic. And one thing is if you say something that's just not right, if
Yeah.
you say the trial judge said X, and when the other counsel comes up and takes you to that passage of the decision of the charge is not what the trial judge said, or the evidence before the trial judge was, uh, you know, characterized in a way that again is not faithful to the text. I mean, inadvertent slips and errors are one thing, but if it's clear there's been a mischaracterizing, again for effect to try to get the most uh, out of an argument, going beyond what the underlying record or decision can support, that's going to undermine a lot of trust and confidence in counsel as well. So that, is a small point, but a really important one.
Mm-hmm.
It's your reputation and the integrity that I think you start with. In other words, we're going to assume counsel are operating with the best of intentions and the highest quality. And when there's one of those overreaching that is shown, it's going to raise a flag. If there's a pattern of overreaching, again, that becomes a real challenge to the effectiveness of that advocate. And on style, again, anything that looks disrespectful, dismissive, bullying, a something that looks like either a personal, a personal insult or offense to another counsel, anything that looks like what we would characterize as sharp practice,
Mm-hmm.
Especially in the appellate context, is not going to go over well. And by the same token, those acts of it may just be kindness. If you see an opportunity, a request for an adjournment because of an illness, a challenge in the scheduling, can we finish early by agreement on, for these personal reasons? All of that. I mean, it started, I think, to be highlighted during COVID, and everyone was under a lot of stress, and those appeals to the shared sense of community in the
Humanity, yeah.
appellate practice and,
Yeah.
general kind of professional life, it just goes a long way to show that kindness and respect, and to never lose sight of the humanity that forms such an important part of the adjudicative process. So as much as there are things to avoid, there's also opportunities, and to show you're the kind of lawyer who steps up in consideration of what your opposing counsel might be going through, or shows that kind of understanding if you're a seasoned appellate counsel and your opponent is there for their first or second time, to see the ways in which that can be taken on in a positive way, not to take anything away from the zealous advocacy you may be bringing for your client, but to show there's an understanding of what that opposing counsel might be going through in that moment. That goes a long way from the bench's perspective. It's exactly what you want to see. You want to see the best side of the profession and the best opportunity to put the strongest arguments forward. That's the secret sauce that's going to make for good appellate decisions. So again, that may be, I can't speak for all my colleagues in that
Yeah.
regard, but I think there is a groundswell of support for that approach to this practice. We want it to be a fulfilling one, an engaging one, and we want it to put the client's interests forward in the best way possible. And we want the best appellate decisions that are possible.
And Your Honor, because I am mindful of your time, but I just wanted to end here with one last comment, maybe that you can make for, especially for new lawyers, because for many lawyers who are going to be arguing their appeal at the Ontario Court of Appeal for the very first time, this is going to be the most stressful and the most difficult thing that they will be doing in their career. So maybe if you can give us just some last words of encouragement for those lawyers who will be appearing for the first time in your court.
Yeah, I mean, I'm delighted to do that. I mean, it's a big deal to be arguing in a case on appeal. It's because there are issues that go beyond just the questions that arose in a criminal proceeding. There's something broader at stake that either needs to be corrected or that has implications for others. So I think to bring that forward like this as a lawyer in your first years of practice, first time in this setting, it's important sometimes to make sure it's clear that this isn't about me. It's about something I care about. I care about the client's liberty or interests being put in a way that is going to be important for them and others in their position. And there's something that I care about that needs to be conveyed to the court. So sometimes, again, making it more about the role you're playing can be helpful in kind of diminishing that sense on the nerves front. But also to know that we welcome people to the role. We want it to be a broad and inclusive bench. We want it to be a broad and inclusive bar. We want to have new voices, new perspectives. We want to see, again, a profession and especially a criminal defense bar and a crown bar that reflects the community, that cares about the broader implications of criminal justice, the systemic issues, the individual issues. So, in other words, I think that sense you often hear of imposter syndrome, or is this really a role that I'm qualified for? Our answer is an enthusiastic and full-throated yes. We want that perspective. We want fresh eyes. We want your background and experience to inform how you shape advocacy. And this isn't like you coming to read a script that other people have written. This is you getting to take a look at how the script unfolds and to write your own and to make sure that it is something that you see your imprint on, and that imprint, together with all the imprints of all the other counsel, is what keeps it not only vibrant and engaging for the bench, but also improves it over time. I don't think any of us look at the criminal justice system and say, boy, have we solved that. We all see room to improve and enhance the advocacy and the implications of that advocacy for all the people whose lives are affected. And your voice and your perspective on that matters. And so by way of encouragement, I'd say it's not just about you, but second, it's also about you. And you are very much in the right place at the right time when you first come to argue that appeal. And I look forward to being the one who's lucky enough to be on the bench to welcome that person in their first time standing up.
And I know I said I was wrapping this up, but I do have one last question, if you don't mind, Your Honor. And I promise it will be the last one. But how open is the court to a novo argument?
Well, I think whenever you hear this is, not something that courts have accepted in the past, or it's an unsettled question, what you immediately want to hear is something that puts you in a context that is one that you can align with the broader values. So in other words,
Mm.
you want to have a sense that this is going to be an incremental and important and necessary evolution of the issue, not something that is indeterminate, open-ended, could have all sorts of slippery slopes and effects that are inadvertent and unknown. You want it to be, even if it's a fairly important step forward, you want it to be in the context of well-accepted principles that simply haven't been applied yet or properly to a changing context. And I know you did a session on Mikovits the other day, and that's a good example of where there had to be some novel arguments
Yeah.
on just the emerging digital sphere in which we live and how that affects some well-accepted doctrines when it comes to searches and Section 8 and so forth. So I think that notion of both, it's novel, it's important to advance the law. The law can't be static, but as it advances, keep in mind that court's reluctance to open up doors that are going to lead to uncertain and potentially negative consequences. So making those arguments that show this is incremental, it's necessary, it's understood in terms of broader principles, and it's going to keep leading to positive and important and necessary evolution in the criminal law. Those are the ways to take a novel argument and make it an effective and a necessary change. And again, no judge is going to take the view that the criminal law ought to be static, especially the interpretation of provisions in light of new circumstances in the world, and whether it's new technologies or the effect COVID had or experiences that are clearly disruptive. Responding to that with a principled approach, even if a novel outcome, is a really important opportunity for good advocacy.
All right. Well, thank you so much, Your Honor. This was a very informative interview. I learned a lot just from having this chat with you, and I'm sure many of our audience will appreciate this interview and the time that you took to give us these tips. We don't really hear that much from the Ontario Court of Appeal, so it was a very nice opportunity to hear from you, and I appreciate your time. And I hope that we'll have more sessions with you in the future, especially that you're a Wicked fan.
No, I was going to say it's a privilege to be a part of the interviews and the series, and I really think the more the bench and the bar are able to understand each other's priorities and the shared sense of community that we bring to the criminal justice system, the better. So thank you for the opportunity, and look forward to continuing the conversation with you and other Wicked members and other members of the criminal bar over time, and to keep learning myself as well as to what those top of mind questions and concerns are.
Thank you so much, Your Honor, and I wish you a wonderful rest of the day.
You too. It's been a pleasure.
Thank you.